being completely negligent.
You're not convicted of being negligent. You're convicted of intentionally tampering with evidence.
When this process server tried to call false proof of service a simple mistake, the judge shut it down and explained how her actions threatened the entire due process system.
Brittany Abbott, file 25-7088FH, here for sentencing on a charge of evidence tampering. It's a 4-year statutory maximum and a guideline range at 0 to 9 months.
Sounds like an interesting case to me, and she gets hired on, or some firms that are collecting credit card debts, and she's to serve people, and there's not really much training as to how that service is to be done. I think she now understands the ramifications of what had happened. She has expressed to me she's very apologetic to the victims in this case, and sorry that if anything happened with their case, that she's sorry about that. I would ask the court to follow the agreement that we have for this 6-month delay.
I wonder about those facts. She filed a proof of service with the court indicating that she had personally served the named people at an address and the location, and included a description of the person, including, it said for one of them, described his appearance, including having a missing ear. So that sure sounds like Miss Abbott is intentionally trying to say, yes, I personally served this named person when she didn't, and not just some sort of technical mistake that she didn't know she could leave it with someone else at the household. Proof of service is signed by her, right?
It would be electronically on her phone through that application with the company that she has. And she's accepted the responsibility by entering into this delay that she knows that it was not proper, and we're not making any excuses here, Your Honor.
Well, it sounds like you're saying she's not technically guilty of intentionally tampering with evidence.
Yes, I would like to sincerely apologize for being completely negligent.
See, okay, okay, hang on. You're not convicted of being negligent. You're convicted of intentionally tampering with evidence. So let's start again.
I was incredibly naive. I did not understand how to do my job at all. I didn't understand how to be a process usually, so I just want to say so.
All right, Ms. Abbott, I don't buy a thing you're selling me today. What you're saying is true. At the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. Making a mistake at your job is not a crime. I probably did it today already. You wouldn't like it today if I sentenced you and you weren't even here and didn't know about the case, because you're entitled to due process of law. By your lies to a court, you deprive one of your fellow citizens of notice and an opportunity to be heard. I think that's a pretty crummy thing. And serve 6 months in the Sheboygan County Jail with credit for 1 day previously served. You can either accept my sentence as I've announced it today, or you can withdraw your plea and it goes back to a pretrial posture, and we'll schedule the jury trial on 2 counts of obstruction of justice and 2 counts of evidence tampering.
Yeah, we would like to withdraw our plea at this time.
Okay, Ms. Abbott, your plea will be withdrawn. Well, let's schedule this for next Tuesday. Don't wait for the mail.